Mr. Chair.
Call the meeting to order. I'll start with the Pledge of Allegiance. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call.
Mark Finkel.
Here.
Albert Hayes.
Here.
David Bergstrasser.
Here.
Anthony Netto.
Here.
Jeffrey Rosenthal.
Here.
Robert Smullen.
Here.
Robert Leslie.
Here.
Robert Fultan.
Here.
John Hudson.
Here.
Stephanie Rozicki.
Here.
Richard Ferrara. Here. Mr. Chairman.
Thank you very much. Next thing is the adoption to adopt or revise the meeting agenda. There's no need to revise it as far as I know. So I'd like a motion to adopt the meeting agenda.
So moved.
Mr. Bergstrasser.
I'll second.
Mr. Netto.
Any further comment? All in favor?
Aye.
Any opposed? The next item is introduction of guests and public comment. I assume most of the people here are hearing public comment on the grievance hearing, and with your permission, we'll move all of that into that portion and not do it now. Is there any other public comment that is not to do with that? Okay, well, that moves us right into the Black River Apportionment Grievance hearing. And as you see, we've broken that into three parts. The board hearing, and we do want to hear your comments. I mean, we put this together thinking it was fair and equitable, what we've done in the Southern District, and we are just, we're willing to hear. There's no, we want to hear it all out. There's no time constrictions, there's no pressure, there's no, take your time, let us know what's going on. And then we will discuss it amongst ourselves, and if there's action to be taken, we'll take it. If further consideration is needed, we'll do that. We hope that we're trying to do this as fairly as we can. So we will start with A, and I know there's the gentleman here before us want to discuss it. So whatever order you want to go in.
Yeah, I guess whoever arrived first.
Do you want me to go through the names here on the...
I'm David Paulson. I'm Jefferson County attorney, and I just have some brief comments. I think you all have my written comments, which are more voluminous, and I will stand more or less on those comments. But I do want to reiterate what I feel are what's lacking in the board's action at this point, and why I think it should be nullified by the board at this point and reconsidered. And primarily my comments I want to redirect you to the statutory authority for what you're attempting to do, Environmental Conservation Law 15-2121. And what's lacking in my eyes is there's a lack of nexus between identification of the benefits that you are attempting to levy against. I'm going to speak for my county, but I think it stands for all three counties here, probably all five, and the proportion of benefit which the levy is made against. The statute requires that you identify the benefit, and what was served on Jefferson County at least did not identify any benefit. As I stated in my papers, there's some broad discussion in ancillary paperwork that was served on the county about benefits from flood control. Well, okay, yes, flood control is a benefit that is derived from what you do here. But I think you have to drill down much deeper than that in all three counties. And even within the county level, you have to look much closer at the municipalities, if that's where you're going to make this assessment, at where those benefits go. And I made the point that in Jefferson County, at least, the Black River is, by and large, contained within a gorge. There's very few areas that are subject to flooding, mostly in the eastern end of the county, I guess. The county itself does not own infrastructure which is subject to flood damage. We do not have bridges. One bridge over a hydro canal. That's it. We do not have roads that are nearby the Black River. We have one that goes along the Black River outside the city of Watertown. But again, I believe that's on high enough ground. I doubt very much that it's in great danger of flooding. So to assess against the county as a whole for benefits that it does not receive is patently unfair. And I believe it escapes the logic and legislative intent in the statute. And again, I call you back to the definition of benefit that is contained in environmental conservation law, which is benefit to municipal water supplies. Again, Jefferson County has none that I'm aware of. Navigation on the Black River, none in Jefferson County. Industry, well, our paper mills are pretty much shut down, and I don't know that any of them are in danger of flooding. And general welfare, well, how do we define that? It needs to be defined somewhat more specifically than what I've seen, at least. The second question is, you're reapportioning your assessment in the whole district. Why is that, and what is your authority for doing that at this point? Your statute says that you can do it, but it gives only two circumstances to do it. One is if powers be developed, which I'm not exactly sure what that means, but I'm going to assume it means that if powers are granted to the district by the state that require additional revenue. I don't think that's happened. And the second circumstances are when a public corporation becomes equitably liable for parcels that are benefited. Again, I don't think there's any basis for that here. Neither Jefferson County nor any of the others I'm aware of have purchased parcels within a zone that is benefited by any of the items that I've listed above as benefits under the statute. So my argument would be that there's really no basis under the law for reapportioning at this time. There's certainly been no identification of the benefits, and therefore we're in the territory of an arbitrary and capricious action. And that's my
Thank you.
comment at this point.
Any of our staff comment on that? Those points?
Sure. I think the key for us is to understand at this point that the board has been through this process before. And it undertook that process on the Hudson River area to reapportion with respect to expenses incurred on the Hudson River area, and have chosen this time to follow a very similar methodology. And we did so because we had already vetted out a lot of the issues that Mr. Paulson is bringing to bear. The definition of benefits was central to the complaints lodged by the Hudson River counties with respect to the Hudson River apportionment. So that issue has been determined both by the board, subsequently by the Supreme Court, and subsequent to that by the Appellate Division for the Third Department, and the Court of Appeals ultimately declined to look into the matter when the counties on the Hudson River side had brought the matter that far up the chain. So we're confident that the identification of benefits, as articulated by staff in our memos, falls within the definition already vetted out through that process on the other side and the subsequent court cases. Also, Mr. Paulson spoke of looking at any of those benefits and how those benefits apply to the county, suggesting that we drill down into the municipalities to further define how those benefits affect the individual at the lowest possible level, so to speak. And you need to, the board needs to understand that this also was an issue for the counties on the Hudson River side. They also objected to the concept that we would aggregate those benefits to the county level rather than dial down into a town, a village, a municipality, a school district, some other lower level subdivision of government. You know, at the city, town, village level, there are more readily identifiable benefits. But when you bring this apportionment down to that level, you lose the benefit that the county gains by a continuation of activities in one portion of the county that, although not happening in another portion of the county, do benefit that other side of the county. For instance, where roads and bridges are washed out, it's not only the valleys that are suffering, it is also the hill towns which can't access their necessary daycare center, their retail outlets, their grocery stores, their hospitals, their doctor's office. So by expanding out to the county level, we tried to spread that benefit among the greatest number of people that it made sense to spread it among. That also was litigated on the Hudson River side, and also that argument was soundly rejected by the courts. We won in that respect. The county not owning infrastructure that is subject to flooding misconstrues to some extent how this assessment or how this apportionment is set up, and really dovetails nicely with Mr. Paulson's last argument, where he speaks, you know, if powers are developed and the county becoming equitably liable. The county itself isn't necessarily the owner of the properties that are at question. If you look at our statute, it speaks of an apportionment among the, you know, I'll even pull out the words because I'm missing it. It's easier to read than to remember. So the board shall apportion the cost less an amount chargeable to the state among the public corporations and parcels of real estate benefited in proportion, blah, 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 blah. So parcels of real estate and public corporations. The parcels of real estate for the purposes of this apportionment are the hydropower companies or hydropower parcels of real estate upon which hydropower is developed. And you separate that out from the public corporations that are affected. So for the calculation of a benefit to a particular entity, you have to separate out whether you're talking about parcels of real estate or you're talking about public corporations. In this case, obviously the county is a public corporation. It's not a particular piece of real estate that's subject to this apportionment. In calculating how to apportion among those beneficiaries, whether those beneficiaries be owners of parcels of real estate or public corporations, the board asked staff to evaluate the total value of property in each of those public corporations and compare it against the total value of property in all of the affected public corporations. So in that respect, it doesn't really matter if the county is the owner of the parcel of real estate. It merely matters if the I'm doing exactly what Mr. Polson did because it's hard not to. It doesn't really matter whether the county owns the property within its boundaries, notwithstanding that that particular piece of property is not a hydropower company. It matters that the relative value of all of the affected property in that county is compared against all of the property in a greater subset of all of the counties. I think you guys get what I'm talking about. I'm not sure you guys get what I'm talking about. I mean, we've kind of been through it before, and I'm kind of trying to articulate for the record where we are. But the idea is that there's a particular way that the board is looking at parcels. Now, and the final argument Mr. Paulson made had to do with the authority to do the reapportionment. If powers be developed and whether any particular entity is equitably liable. If powers be developed really concerns whether a new hydropower entity is developed on a particular river. If an existing apportionment is moving along and there's 22 different hydropower companies and there's 5 different public corporations that are affected by that apportionment, and everybody is moving along for several decades, and all of a sudden somebody builds a new power plant. That new power plant, until it is made part of the colony of power plants that are paying a portion of the district's expenses, is outside of that apportionment and therefore doesn't get assessed. So a new power developed often would necessitate a reapportionment of the costs among all of the available parties.
It's not speaking to the authority of the board, a new power of the board.
No, it's not a new power of the board granted by the legislature. It's literally a new player in the game that ought to be paying part of the expenses of the district. That's the way we've looked at it for 80 years. 8 for me, but over time. And then the other side of that is who is equitably liable, and I think that's, that theme came up. Why us? Why now? You've never got us before. Why are you getting us now? Where we had a lawsuit that challenged our assessments under the existing apportionment, and that lawsuit was settled, and part of that settlement said that we would reapportion the costs to run the district to eliminate that entity that complained that it was not equitably liable. You take that entity out of the mix, and you're left with everybody else. At the same time, which, similar to a new power being developed, that's a power being taken out. So, they didn't write it in the statute as a power being eliminated, but that's basically what that lawsuit settlement did, was eliminated a power from being one of those that are being assessed. So the new power being developed puts in a new entity, the power being taken out takes out an entity, and then there's also a discussion in an audit by the comptroller that spoke to the board's inability to get various entities to pay their assessment. The way that the assessments are levied and collected is set in statute. You guys have had a portion of that responsibility along the way, sometimes exercised, sometimes not. And I don't think there's any question that when not exercised, we understood why the various counties didn't want to exercise their responsibilities. But where an entity that was subject to an assessment failed to pay that assessment and over several years continued to fail to pay that assessment, the comptroller came to us and through part of an audit said, you have to write off those amounts. You guys understand, because of what you do in taxation and assessment, that we can't just write off those amounts. We're not a corporate entity. So we wrote back to the comptroller and said, you guys basically misunderstood our statute. What you're telling us is that we need to eliminate from the apportionment those entities that fail to pay their assessment. So the board has been approached by various entities that don't want to pay their assessment anymore. Some of you have been approached by those same entities saying, we ought not be paying our assessment because our mill is closed, because the water that flows by isn't enough for us to make money, or the lumber that we used to make isn't profitable anymore, so we've closed down. And now we've got this Black River area assessment that we don't understand and can't pay, so we're just not going to pay it. The comptroller came to us and said, you need to take action. You need to write those things off your books. The only way we can write those things off our books is by doing a new apportionment so that we eliminate those entities that aren't paying for whatever reason, a defunct mill, for instance, or a vacant piece of property, in the case of Niagara Mohawk, our favorite. So that's the equitable basis for the board to decide that it needs to come up with a new apportionment. So when you look at it in that view, the statute speaks exactly to that paradigm. It gives you the opportunity to create an apportionment to build a reservoir, and when new powers are developed that should be paying for portions of the cost of that reservoir, to reapportion to add them in. Conversely, when powers that were developed are gone, you reapportion to take those powers out, to reapportion among everybody else that's left. And in the case where there's other equities at bar, to do an apportionment to properly spread the costs among everybody. 1959, these two districts came together. 19 something, the low teens, the first apportionment was done. It's time to reapportion those costs to equitably spread them around among everybody around. So, does the board have any other question about?
No, I was just gonna ask.
I only have a comment, so that it's not lost in the discussion and in reading some of the other concerns of the municipalities. This discussion about the exercise on the Hudson River side should in no way be construed or misconstrued, if I'm correct, that there is any effort to shift some of the expenses on the Hudson River side to the apportionment on the Black River side.
That's correct.
I just want to make the record clear that the exercise or the example, the illustration of what happened on the Hudson River side, other than the model and the effort going forward on the Black River side, is not in any way merging the budgets, clouding the budgets, shifting the responsibility.
Correct.
I have a question. Is this reapportionment only one, say, a remedy where counties choose not to collect our levies?
I think it, from my perspective, it was a factor, but it's not necessarily the determinative factor. Counties hadn't collected our levies for a long time.
Sure.
Rightfully so in certain instances. If a defunct mill is not paying their bills, and part of the reason they're not paying their bills is because they have other problems that have nothing to do with the counties or with us, but maybe an environmental problem on the property, and the county's ultimate remedy on our behalf, collecting this assessment in the manner that taxes are collected, is to foreclose upon that property. And the county doesn't want to foreclose because they don't want to take on responsibility for this environmental mess. We understand why it didn't happen. And we worked with the counties along the way to say, hey, you guys need to collect. And the counties gave us good reason for why they didn't. And we said, all right, well, we're not going to collect that money. We understand that. The comptroller didn't understand that. And they got pretty pointed about the fact that we needed to compel the counties to go after those entities that were unable to pay. It wasn't expedient to force a county to do something it was dead set against doing, nor to try to get blood from a stone. Can't get money from a mill that's been closed for 15 years and has no intention of opening up again.
And one of the issues there is that the counties are not required to make the district whole as they are with other taxing jurisdictions.
Right. So, they're compelled to collect our monies, but if they don't collect our monies, all we can really do is compel them to take the action. And if the action is unsuccessful, we don't get the money anyway. County has a lot of expense, we had a lot of expense, and that expense would far exceed the amount of money that we would actually attempt to collect. So everybody made the right choice at the time the choice was made, but along with the fact that Niagara Mohawk basically made a somewhat compelling argument that they shouldn't be assessed for their vacant properties, any more so than a defunct mill ought to be assessed, and to clear up some inequities in the manner in which this last apportionment had been rolling along for decades. It made sense for the board to exercise its discretion and conduct a new apportionment, equitably spreading those costs among the counties that are named and the hydros that are named. I've been sucking up a lot of oxygen, and I think
That's all right.
it's a shot.
We're here for it. Anything
Good
further
articulation.
you'd like
Yeah,
to
if I
add?
could just comment on a couple of points Mr. Leslie made. I tend to be a statutory attorney. I read them quite literally. I appreciate some of the explanation that he's given on your interpretation of the statutes. It certainly helps me understand better where your position is, but I still maintain that regardless of what was determined in your litigation on the Hudson River side, that you are required to make the findings regarding benefits specific to the Black River side and this assessment, and that those should have been articulated in the assessment you made. And particularly in the analogy that you made regarding the counties and deriving benefits even though they don't own infrastructure. You made the comment about, well, if certain bridges are washed out, there's a detriment to the community, granted, but don't you have to determine which bridges are at risk because of flooding? I think that's an important calculation that needs to be made by the board. And what if there are no bridges that are actually at risk of flooding and where they're not flood flow control because of the dams in your river? There may not be in particular areas of the county. I think those things are important to articulate, and they have to be articulated for each political subdivision. You can't just throw a big brush saying, well, they have to be benefited somewhere, and because the county is the biggest subdivision, we'll assume that they benefit somewhere. I think if the state legislature intended that, they would have said counties rather than political subdivision. I think that's just a basic premise of due process. Secondly, the fact that the matter may have been litigated in the Hudson River side, that's true. That is in the 3rd Department of the New York State Appellate Division. We are in the 4th Department. Many of the precedents that may have been set at the trial court level, I believe. Some of them were set by the 3rd Department. But certainly, we could have a different result here in the 4th Department. It was litigated here, and many of these matters could wind up at the Court of Appeals. So I don't think we can assume that everything has been settled. I will leave my comments at that.
Right.
Thank you very much. Next up, and you people sign have to be, you have to write better. I can't read names here. Robert Malone from Herkimer County. Welcome.
Morning, everybody. I'm Rob Malone. I'm maybe the 4th Rob in the room. I'm the oldest, so I think the rest were named after me. But I'm the county attorney in Herkimer County. First of all, I want to congratulate and thank your staff. Came and met with us, very polite and forthcoming. I've spoken with your counsel several times. He's been terrific to talk to. And I want to compliment you on your staff, first of all. And secondly, I've submitted arguments in writing, and I think Mr. Paulson made some excellent legal arguments. And he's focused on perhaps more on the issue of can you do this, and my argument is focused a little more on should you do it. We're reserving our right, of course, and I did that in my paperwork, to challenge on the issue of whether it's legally proper. But our issue is one where this is something that it's new for you. You have not assessed counties in the past. It's brand new for us. There are tremendous fiscal pressures on counties. Jim Wiles is here, our county administrator, who's probably one of the best in the state on analysis of fiscal pressures on all municipalities, especially counties. We're facing a tax cap of 0.67% this year. So this initial assessment for us is only $13,000, but it's something new for us. We're extremely sensitive to fiscal issues and under a tremendous amount of pressure. And I think we're all from upstate New York and understand what's going on here. Also, in the course of my research, I believe that this originated in what happened on the Hudson Valley side, not on the Black River side, that you lost the ability to assess hydro plants which were federally licensed on the Hudson River side. That caused you then to seek money elsewhere, and then you turn to assessing the counties on the Hudson River side. That's been litigated in the third department. I don't know, do we have to go back to Albany County to litigate this? I'm not sure. Some federal agencies we do, but
I think you can choose
Okay.
where you want the venue to be. My guess is you'd choose your own Supreme Court.
so probably we would be back in the fourth department. But in any event, what happened we're hoping that the board will decide that what happened on the Hudson River side should not translate over to the Black River side. It's an entirely different situation. You have not lost the right to assess hydro facilities in the Black River side because they're not federally licensed. You could continue just as you have been, no change at all. And that's what we're encouraging you to do. As I've listened a little bit this morning, apparently finances are separate, which seems appropriate. There was a merger that took place at some point, but not a complete merger. And we think that the rationale for assessing in the Hudson River Basin should not be applied over here because there's really no, let me quote myself, no compelling financial or policy reason to assess counties here. So that's essentially our argument. I did want to indicate also, other than just that rationale, there are big differences between what happens on, in that part of the state and what this part of the state. Maybe we're a little poorer over here. Maybe a lot of demographic differences between what happens over there and over here. And we'd ask you to keep that in mind. And lastly, I'm not sure if I heard correctly, and Mr. Leslie will correct me if I'm wrong, but if the rationale for assessing counties is in part because counties have not been doing their job, I wanted to clarify my understanding of that statutory situation. I'm the person who forecloses against property in my county. We do not have a responsibility to foreclose on every parcel. The statute specifically says we do not have to foreclose if we're likely to be damaged financially in the foreclosure process. If we take something that's contaminated or has to be torn down, the statute specifically says we do not have to take title to it. That was not always the case. For many years, counties were required to go forward on every parcel. We'd wind up with parcels that had to be cleaned up or torn down, cost the taxpayers, the county taxpayers, huge amounts of money. So the statute was changed, so we do not have to do that. So we don't feel that we would be not fulfilling a responsibility if we made such a decision not to foreclose on something you have an assessment against. So that's essentially our situation. I wanted to keep it brief. If I'm wrong about the financial end of this thing, I'd be glad to be enlightened, but we feel, in conclusion, that because of what happened on the Hudson River side, I think the board should exercise its discretion not to translate that to the Black River side. There's no need to do so. Your finances on this side are fine. They were not affected by those developments that have been discussed here, particularly hitting the federally licensed facilities. It hurts us badly to be having to pay things that we haven't had to pay before. We have a tax cap. We're bumping up against it. It's 0.67% for Herkimer County this year. 0.67%. It's less than 1%. So we're looking at real fiscal stress. And I don't know if Jim wants to address any of that.
Do you mind, Mr. Chairman?
No,
Maybe
please,
1 minute or
please.
so?
Oh, no, not at all.
Thank you so much. Really appreciate it. As Mr. Malone said, I've been here for about 38, 40 years. Our county fiscally stressed, $1 million sales tax hit this year. Our cap, as Mr. Malone alluded to, is 0.67%. That's $175,000. We had to cut a computer operator part-time because of this assessment. So it's real. The $1 million hit to us in sales tax is real.
just very, very difficult when you're trying, you know, the last 15 years, we've gone from 750 employees, we're down to 398 FTEs right now. We're cutting every place we can, and I think I'm just asking you guys to really consider, is this something you really need to do at this time? Because again, I know 13,000 and change doesn't sound like an awful lot of money to some people, but for counties like ourselves, and I think the other 4 counties, it's real. And in this case, we had, you know, in the budget now, the money's there. We had to delete a part-time computer operator, and that's somebody's livelihood, that's somebody's job. But because of the cap, our taxes in the valley are $60 a thousand, some of the highest in the country. We just can't ask people to pay more money. So I guess I'm pleading to you guys to really consider if this is something you really need to do, or is it something that could be postponed? With that, thank you.
Mr. Chairman, I had one more
Oh.
point. I don't believe Herkimer County has ever not gone forward with a foreclosure on any of your parcels, to collect any of your assessments, either. Now, that isn't necessarily determinative of what happens here, but we do look at each parcel when it comes our way to see if we can move forward and help people out. I'm sure we would do that in the event that ever came up with Herkimer County.
Right.
So we'd continue our, cooperation, and like, we've had a very good relationship so far, even during this difficult process, and we want to continue that.
I don't want to leave the board with the impression that there's a cause and effect between the counties in each individual instance I've seen right or correct decision to not pursue. It really has more to do with the comptroller telling us we need to take every step we can take or write things off our books, and we just can't write them off the books. We don't have the authority to just say, you know what? You don't have to pay. So we have to reapportion in order to address the concerns the comptroller brought to us.
And we're asking that reapportionment be limited to the folks you have always traditionally assessed, and not to shift that to public corporations, to the municipalities.
Anything else? Board questions?
Not at this time.
I have Lewis County. Joan.
Good morning. I'm Joan McNichol, the Lewis County Attorney. Mr. Chairman and board members, I do want to thank you for coming to Loudville so I didn't have to travel. We appreciate that. And I do want to piggyback onto my colleagues from Herkimer and Jefferson County. They have made very important persuasive arguments, I believe, that Lewis County also follows. So what I would like to do is focus on the equitable arguments on behalf of Lewis County. You have my written statement, and so I'm just going to highlight some of that and add to it. I will also want you to know that the chairman of our board is here, Mike Table, as well as the chair of our Ways and Means Committee, Philip Hathaway, who will fill you in on a little bit of the numbers for our county after I've finished my short remarks. And I want to say, in terms of equitable liability and arguments, we do know that you are charged with maintaining the rivers, and I would suggest to you that because we have never been assessed, the counties along the Black River, Lewis County in particular, and I know our counterparts in Herkimer, Jefferson, and the others, have also maintained and been responsible for our portion of the river in our communities. Lewis County itself places flow monitors on the bridges along the rivers at our cost, at our expense, at our employees' time and expense, and has done so forever. So I would suggest that I'm not so sure that you're charged to maintain the rivers along the Black River, have you had any expense for those matters? We have been the ones maintaining. We do have some flooding at times. We have had bridges washed out. It has been the county and the county's resources who have taken care of those situations and have addressed the proper authorities to get reimbursement for expenses when we've had washouts. Our Director of Planning, our Soil and Water Director, our emergency management people all work together and continue to work together in Lewis County to monitor the river and its flow. That you should be taking that into account in whether or not any assessment should be made to the county. We've been acting as your district maintenance people here. I can tell you, and maybe you know, but from our employees, we know that the cost of each one of those monitors ranges from anywhere from $6,000 to $12,000. All of our rivers and all of our bridges are all monitored. The county has transferred boats to Soil and Water to assist them in monitoring the river. These are all charges that if you were taking care of maintaining the Black River would have been done by you. We're happy to do it. We've done it forever. Don't start to charge us for the fact that we've been taking care of the river. We are subject to a tax cap, and I know you've seen that in my papers, that I would suggest to you, as Mr. Malone has suggested, is that you should not make any changes to how you have apportioned assessments on the Black River side. Maintain the system as it is. The hydros along the Black River are paying their share. We have been maintaining the river flow maintenance. Our treasurer has assisted in re-levies from time to time in Lewis County as well. We also are very, I would say, aggressive in taking care of delinquent taxpayers, although we are very careful not to put the county in the position of being environmentally responsible. And so, especially for hydros, we would be very cautious about taking over or foreclosing on any property involving a hydro. That's not to say it can't be done, or that we wouldn't look to do that, but we would look to be sure that the county was not placed in a liability position. I would also suggest to you, and I think my colleagues have also made this argument, that we are very different here on the Black River side. We are not Saratoga County. We are not Albany County. Our economics are very different. We are very rural. We are poor counties here. Every dollar counts. We are in the midst of coming to a budget approval in the county right now, and Mr. Hathaway will address that. But we have made significant cuts. I would suggest to you, since you are not subject to a tax cap, that maybe you ought to consider that, especially in whether or not you're going to start to reapportion it and assess the counties on the Black River side. Make some cuts to your operating budget. You can do it. We've had to do it. Don't assess us and cause us to have to cut even more services and benefits to the people of Lewis County, especially when we've been the ones who have been maintaining the river and maintaining and watching the flow and dealing with any floods that have occurred. I would also ask you, and I don't know the status of it, but I do know that your board is not fully developed. We are, in terms of fairness, you have to have a full board, you have to have full representation from all sides and from all communities. I think we're lacking in that respect on your board from the Black River side, and I would request that you deal with that and fill those positions as quickly as possible. There's nothing worse than a board is coming down with regulations upon a community when they're not represented. So please address that as quickly as possible. I again request that you reconsider the assessment that you've put onto the county. It's a big number for us. It probably means a loss of services and other department benefits that will go out to the community. We will continue to monitor the river in our district and to take care of flooding and controls. And you don't need to treat us the same as the Hudson River. It's very different. Thank you.
Thank you. And just to answer, we do have two people from the Black River area on our board now. This gentleman and this gentleman. He's from Watertown. You're from
Old Forge.
Old Forge.
Right.
And we have
Already
requested
on
many
board.
times to fill our board out. We have applications sitting in Albany waiting for their approval. I mean, we share the same concern about not having the board full. But it is represented. I mean, we have 5 people on the board. 2 are from the Black River area currently. And we do want to fill it up, I mean, for sure.
Do you know the time frame when that might be?
We're dealing with appointments.
The nomination
been
is
submitted.
in the Governor's Office of Appointments, and I know a background investigation has been initiated. When the governor will make those appointments for the one vacancy that you're speaking of, I was hoping by now, but I don't have an answer for it, obviously.
We're tight. I have a board member who leaves for Florida for 3 or 4 months, so.
Is that you?
No. I wish, but no.
Thank you.
Thank you. I'm sorry, did anybody have any questions for her or comments while she was here? I'm sorry, I didn't mean to dismiss you.
That's okay.
Folks?
I
Okay.
would,
Somebody, you wanted to speak some?
Yeah, just briefly. And again, I'll parrot Joan, I appreciate you guys coming here to meet with us. My name's Phil Hathaway, I'm a legislator of Lewis County. I have told you before that I really wasn't overly enthusiastic about this levy that we've gotten, so I won't get into that, but to parrot the other gentleman regarding finances, our tax cap was $238,000, and we are faced with healthcare alone of an increase of $450,000. Not to mention any other raises or other services or whatever. So we are really under a serious situation with our budget. As the chairman would concur with, we've been burning up the internet over a $726 item that's going to be a bloodbath at our budget hearing on the 15th. That's the level that we're dealing with. We were $156,000 away from meeting the tax cap. Senator Griffo strongly encouraged us that we needed to meet that cap because of the reimbursements to our citizens. So we're going to have an amending resolution. It's probably going to be about 3 pages, and it's going to have $100 here, $500 there, just to meet this 156. And for, again, I guess I'm going to reiterate what I said before, but to have this come up to us like it did in my mind, at the spur of the moment, that now we've got to come up with another $19,000. It doesn't sound like much, but it is much, and it's hurtful to us. And I'm not really enthusiastic about this process. I'm not enthusiastic about this process because you guys are the ones that are putting this burden on us, and now we're here talking to the same people. Like, when we have a grievance in our town, we have a separate independent grievance board that adjudicates these things. But now we're talking to the people that have levied it on us, and I don't mean to be, I hope I'm not being disrespectful
Not at all.
in saying that, because you're obviously quality people, and I appreciate that, but it's just the process. And actually, Mr. Leslie, it seems like you are taking the charge to refute what these various people have said, and I thought this was more like an open forum that we get to say how we feel about things, and you take that into consideration. And again, I don't mean to be offensive to you either. I hope I'm
I
not.
asked him for that opinion, I'm sorry.
Pardon me?
I was concerned, I asked him for that opinion.
Okay, then I'll be upset with you then.
Yeah. I get you, Ken.
But that's pretty much all I wanted to say. I wish we could maybe come to some other accommodation or agreement for maybe it happening in the future or something like this, but
All right, thank you.
thanks for your time.
Any questions? Anybody else? I didn't skip anybody, right? We didn't skip anybody? Well, having listened to everybody here, I'll be honest, I got some concerns about the tax cap issues that we talked about.
I can concur with that because I sit on the board of the town of Webb, and we just passed our budget last night, and we had to do a lot of nipping and cutting and sacrificing to stay under that 0.67% tax cap. So I can feel for you.
So the question, knowing the pain that counties go through to keep under the tax cap, why wouldn't your board set an example and do the same? You're representatives of the state yourself.
I'm going to reconsider.
I'm thinking, we don't have to rush through this. I don't know how everybody else feels, but I think we should investigate this a little bit. I don't know how everybody feels.
I appreciate all your input.
And maybe we should table the action for now and do some, I don't know, you had some, you were like crazy. Did you have any comments? I saw you writing like crazy.
Oh, no, I was just taking notes of people's arguments, but I guess one comment I have is, when we asked the staff to draw up this plan for reapportionment, we had to identify all the stakeholders, and public corporations, the counties are in the mix, and the methodology used by staff is based on a similar methodology that was used on the Hudson River side. It was vetted and litigated through the courts all the way up through the appellate divisions, and it was declined by the Court of Appeals. So I think the methodology used is fair and equitable. And the issue of benefits derived for flood control, I think, are real. And Mr. Fulton, he's our chief engineer. I don't know if you can speak to how that benefit was derived and how it was spread amongst the counties in this case.
Well, as you had indicated, based on what we'd gone through in the Hudson River side, it was concluded that there was a direct relationship between or a reasonable relationship that would be used to come up with the apportionment relationship between flood and flood protection and the value of the properties. So the apportionment itself comes from those values of properties with the understanding that whatever the actual quantified dollar of benefit may be, it's proportionate to the value of the properties.
I see.
So the actual calculation of, or even putting a dollar value on some of the potential damage that could occur or value of avoided damage was determined to be a much more tedious process than was necessary to come up with an equitable solution.
Okay, so if I can simplify it then, that the argument is that flood control benefits the parcels such that it increases the fair market value or the assessed value?
Basically, yeah,
Right.
or avoids cost associated
Okay.
with damage.
Okay, in that too, okay.
And that should, you know, that is too, the benefit derived, you know, is, that's only part of it. The other
Okay.
side that actually hasn't really been discussed is the augmentation. And the release of flow, between the three reservoirs that we have, probably close to 4 billion cubic feet of water that's released through the Beaver Black and Moose River. And, I mean, that's substantial, it's substantially important. It's important to the county, you know, waste facilities that have speedies permits. It's important to folks that withdraw water for agricultural needs or for livestock needs, recreational purposes even. So the augmentation side is huge, and it really hadn't been discussed by anyone here today, but you know, there's 3.5 billion cubic feet of water that come out of Stillwater. And I was just looking through my notes, I was discussing, and I had given the, passed along a memo to our executive director back in August, and I was just looking at some of the numbers. The average river discharge during the low flow periods is increased by as much as 26%. You know, that might be the difference between whether or not there can be some whitewater rafting in that gorge in Watertown. And certainly can affect, as I said, speedy permits issues and water and wastewater activities that go on in the river. So augmentation is something that hadn't been discussed an awful lot of that at all, but certainly should be also recognized when we talk about benefit.
Can one of you talk about Lewis County's discussion that they're already doing this themselves?
So
What we propose to be
you're
doing?
speaking of the issue of flood warning and monitoring. So, and I think that's the issue with the Lewis County Soil and Water Conservation District
And the director of planning.
and the director of planning. And so part of the issue that is brought up there is that the river regulation is slightly different than flood warning, is what I think the citizens of Lewis County are interested in most. Would that be a fair statement of where the value is?
I don't know if they really are directed to one aspect of that.
So the gauging and of the streams, we have some of them. Lewis County has put some in. We want to make sure that we fully integrate all available means in that regard. But we think we've got some ideas in terms of flood warning that we might be able to work with Lewis County a little bit more closely on. The main thing that the district does on the Black River side is with the dam and the reservoir and the impoundment of water and when that water gets released. So it's we're slightly talking past one another, and we need to more closely partner with not only Lewis County, but Herkimer, as well as Jefferson counties, in things like we just did our Stillwater Emergency Action Plan to really see how the system can work together for the benefit of all the citizens from the dam to discharge into the lake sort of thing. And that's one of those things that would be a goal of mine, is to be able to make sure that we, the district and the counties, are all on the same sheet of music for all the issues of importance to not only the hydros that are the ones that pay 93% or would under this apportionment pay 93% of the expenses, but for the counties, which would pay 7% of the expenses, so that we're all literally on the same sheet of music of understanding. And that's obviously not the case as we see the various differences of where you stand is where you sit around this issue at this meeting here.
I have another comment and want to defer to Mr. Leslie on this. There's been some comments recognizing there are some economic differences, but the arguments have been made that there should be some disparate treatment. Doesn't that in itself raise, however, a question of equal protections between the Hudson River side and the Black River side if we were to engage in totally different approaches in the manner in which we got to the apportionment? And isn't that in fact something that gave rise to our doing the reapportionment in the first place?
Well,
So that there was some similar equitable treatment between both sides.
Yeah,
That was about
we definitely,
17 questions in one really lengthy sentence, I
Right,
apologize.
right.
With no commas or semicolons.
yeah, we faced an equal protection argument throughout the litigation that we had with NIMO regarding disparate treatment of their properties on the Hudson side from their properties on the Black River side. We recognize that this apportionment, while it only covers 20% of the total costs of the district, will have an effect on the apportionment that covers 80% of the costs of the district. Where the Hudson River side apportionment follows the statute, which requires us to determine an amount chargeable to the state and apportion the balance between the public corporations and the parcels of real estate. I believe that in order to survive that equal protection argument, the Black River apportionment has to determine an amount chargeable to the state and apportion the balance between the public corporations and the parcels of real estate. I get that the counties on the Black River side would prefer that the board choose only the hydropowers because they, to this point in time, have been the sole payers of this assessment. But there's two elements in this apportionment that correct deficiencies from the last apportionment. The first is that we've determined what the amount chargeable to the state is, and we've secured that share from the state already. And the second is that we took a good hard look at the statute as part of the Hudson River side and determined that we're compelled by the statute to charge both the public corporations and parcels of real estate benefited. The board shall then apportion such costs, less the amount which will be chargeable to the state, among the public corporations and parcels of real estate benefited, with the rest of that sentence. We can't just choose not, or the board can't choose not to apportion a portion of its costs against the public corporations. Now, whether these counties are subject to a tax cap or not will change, or to the extent to which they're subject to a tax cap will change each year. But if it's not the counties, it's got to be some other public corporation that we identify. We may be able to justify choosing a different public corporation than the counties.
And that would be smaller municipalities?
Yeah,
As has been
like
suggested.
Mr. Fulton, I have a memo to the board in which I articulate all of the different public corporations that are named in the statute that may be subject. Cities, towns, villages are the obvious. Other public corporations, school districts, sewer districts, other regulating districts. I mean, can you think of, there's a long list of things that it could be. Anything that the board does is going to engender the same argument about the tax cap. We have an idea of what the expenses of the district are. Lewis County identifies several expenses that they take on that they think are things that maybe warrant an offset of their assessment by the amount that they spend on those items. Incorporating those things that are within our mission into our budget may be something the board wants to consider. If it does so now, that's really a modification of the budget upon which the apportionment is based, and therefore requires that we go back to DEC and get a new approval of this new apportionment. I don't know that DEC really has drilled down into the basics of our budget.
Doesn't that leave us with the same specter of an equal protections argument when we have not done so in that fashion
On the Hudson side.
on the Hudson River side?
It does, and it's, I'm less concerned about losing the validity of the apportionment on the Black River side than I am about having the validity of the apportionment challenged from the Hudson River side. Because that's where the bulk of our money comes from. There's 20% on the Black, 80% on the Hudson. General board is paid for basically 20% of the general board cost comes from the Black, 80% comes from the Hudson. Where the Hudson money goes away, that entire general board expense becomes an expense of the district, and if there's no money on the Hudson side, all of it goes to the Black side. Which, to some extent, means that the Black River area public corporations that are challenging have, they have a stake in the fight as to whether the disparate treatment causes a problem with the Hudson River apportionment. Obviously, we, staff, have proposed an apportionment to the board which attempts to ameliorate those concerns by having the methodology similar, having the beneficiaries be similar, choosing similar benefits. All of the documentation behind the Hudson River area apportionment is still out on our website. It is referenced in our memos supporting the Black River apportionment. It's all part of the record. And, we think we've got a pretty tight control on the equal protection argument, among the other arguments we probably are facing. The tax cap, it is going to create some short-term problems. We understand that. But the solution is either get a legislative change on the tax cap or get a legislative change on our statute, because our statute says public corporations get tagged.
What, no, did you?
No, I'm sorry.
I would argue, I do not believe that you are compelled to do so by statute or by any court decision. The situations
Not compelled to do
dissimilar
what?
between the Black River and the Hudson River basins. Your situation in the Hudson River side is dissimilar because you've lost the ability to assess a major portion of your revenues there. You have not, that has not happened here. I believe the court did indicate that statutory interpretation is flexible. The agency does have the ability to interpret, and I believe the dissimilar situations justify dissimilar treatment. I don't believe there's been any holding indicating that you legally must do this. We would argue, and I would argue on behalf of Berkeley County, that this board has the discretion not to do this. If you are compelled to do it, that's a different situation one we would understand. But to do so defensively, to protect yourself in the event something might happen in the future, I understand the argument. However, it has real fiscal consequences for these counties. And we'd urge the board to exercise its discretion not to go forward on such a speculative basis. I don't believe the equal protection argument is compelling, but no holding to that effect.
I don't think,
Well, we are at C.
Can I ask a question?
You sure can.
Where does the 93%, 7% ratio on the assessment, what was the determining factor for that? The hydros versus, you follow me?
Yes.
Yeah.
Question is, who wants to answer that?
Well, I mean, from a strict budget standpoint.
That's all I want to know.
Or assessment, the existing hydros, that was historically, that percentage, the 92 and change, closer to 93, is historically what the hydros have paid. The difference was the hole that was created as a result of the litigation and the inability for the district to collect through its own efforts and the county's efforts, the other
7%.
right, those parcels of real estate that were not paying their assessment. So that was the 6.7%.
Right.
So it was basically determined by how much we could collect over the years versus how much we were unable to. So it's not written in stone.
No, but there's,
Okay.
but we felt as staff that there was clearly a reasonableness to those two percentage splits, the
That's fine.
93
Right.
and the 7.
If we identified how much the hydros had been paying in the past and were basically able to ensure that they paid at least that much going forward, the balance left, most of that was picked up by the fact that we identified in our statute that the state is compelled to put in a state share. So the state put in $250,000.
Right.
The counties are picking up 67,000. What?
Correct.
Okay.
So the state is picking up the bulk of the balance, leaving 7% for the counties to cover.
All right, thanks.
I just wanted to comment to Mr. Malone's point. I think the board made a decision to reapportion, not because of a speculative challenge to any treatment between the two districts. You know, we concluded that it was time to do so, I believe, and based on the litigation that we've been facing. So that was the reason for the decision, at least in my mind.
Any other comments from anybody? Well, anybody feel that there is, in light of everything we've heard today, you want another 30 days to
I'd
study
like a
this?
month to think about it. Yes. See if I come up with any more questions. There's no rush to.
No, there's no rush to judgment here. Is that, we have a motion to table.
I'll make the motion to table it for 30 days, till the next meeting.
Is there a second to
I'll
that?
second that.
Any further discussion? Yeah, I'm all in favor?
Aye.
Any opposed? We're going to table this, and we will take into account what everybody has said today. I can't promise it'll be any different, but we will certainly consider everything that was said today. And so we will bring it up for a vote at the next meeting.
Thanks.
I would just comment that obviously the arguments have been made that collectively give the board pause
Yeah.
so that we are not
Yeah.
willing or able to make a final determination today. And we appreciate everybody's efforts from the counties as well.
December.
I've got it here.
We don't know, I don't know the date exactly.
It says resolution for next board meeting. What? December 13th.
Right.
Where would that be at?
Assuming,
It's in Warren County.
right.
Can
second
we
Tuesday of
revisit
each
that and come closer here?
I would love it.
We could come right back here.
We
if
can.
the board-
We can come here if that's more convenient for everybody.
Sure.
Oh, that'd be fun.
Respectfully, sir, it depends upon what date. in December, because
Yes.
I have some other obligations.
What's the date?
December 13th.
December 13th.
That's fine. That interferes with my tango lesson, but that's okay.
I'm honored to interfere with your tango.
Albert said he'd work with you.
Just kidding.
All right, we're gonna take a break.
Thank you all for coming. Thank you very much.
I have been asked that we take a 5-minute bathroom
Yes,
break.
please.
I've been asked. I said. Does that mess you up?
Take care, thank you.
Are we paused?
No.
Where's Mr. Administrator?
Mine's right here. In his hand, accusing me of stealing.
Motion to adjourn?
I'm sure you would.
Put in your pocket.
Okay, good.
He's going to address it. We'll put it on.
History like he's a liar.
Everybody back? Are you set? Whoops. I just dropped my cap on. Okay, we're back in session. I don't think I have to do it. Oh, I never get to use that. Okay, we have, we're at the, I'm sorry, we have one more speaker.
We do?
Excuse me, yeah.
Oh.
Ed Herbert from CSEA.
Oh, sorry.
Thank you, Chairman and board members. Just wanted to spend a few moments. My name is Ed Herbert. I'm a Labor Relations Specialist for CSEA, and I drove up here to the Great North Country just to take a few moments of your time and to express that again our concerns about the MOA that was completed back in May, and here we are in November. And what we would like to do is to move forward and have the board take a serious look at the MOA and have that hope of having this completed prior to the next board meeting in December. It's ironic that I get to speak to you after just hearing the county speak about their tax levies and their challenges. But at the same time, we have to, as a union, identify our members' issues as well and their concerns, and this is why I'm up here in front of you today, just to share their concerns and to look forward to having this MOA, the memorandum of agreement, and the new collective bargaining agreement, having that signed, and so we can move forward and have this kind of behind us now, and look forward to next contract in 2020. So.
Yeah, and I just want to say, we are also anxious to move this forward and get it done. We're working on getting it approved. I'm pretty sure we will be there at the next meeting. And prior to that, I think Robert will be authorized to deal with the MOA. We are also concerned with that.
Great, I appreciate that, Chairman. I'll work directly with Director Smolin to coordinate those efforts and fill him in on some of the finer details of what took place at the table back in May.
Sounds good. Anybody here on the board have anything they want to say or any comments? Well, you came a long way for 5 minutes. I appreciate that as well.
Yeah. I appreciate it. Thank you.
Thanks for
Thank
coming.
you.
Take care.
Okay, next we need the approval of the September 13th, that's it, we didn't meet in October.
Yeah.
Yeah,
I'll make
because
that motion.
we didn't meet in October, by the way, just so everybody knows, because the two Jewish people on the board didn't recognize that it was Yom Kippur that we had scheduled the meeting. But we did, so.
Mr. Rosenthal made the motion.
Second.
Mr. Bergstrasser.
All in favor?
Aye.
Report of the executive director.
So to be brief here, we did, as the chairman said, we had a month-long hiatus, and the 9 actions that I have noted for the record, I feel fully comfortable and confident to where we're at as far as the Black River apportionment. We did the Stillwater Emergency Action Plan. One of the reasons I brought it up is to demonstrate that we are working with the counties on important issues to their counties and the citizens of the county and the benefits that we provide to them, sort of thing. 2 resolution conferences with Kevin and Catherine King and Lucy Trefaliti Cody. Both parties accepted the resolution of those permit issues. And already noted, I've been working hard with the Office of Appointments to completely fill the board, one for the Hudson and one for the Black River areas. And that really sums it up for today. One thing to note, we did do a technical assistance meeting with the New York Power Authority in White Plains, analyzing the hydro facility at Stillwater Reservoir. And I'd be happy to provide more on that. And myself and Mr. Finkel went to the APA and DC Region 5 in Raybrook to discuss issues of common concern. That's it for me. Thank you.
Yeah, that was quite a trip, if I can comment. It was quite a trip. What was most enlightening is both agencies really didn't have a whole idea of what we did. I mean, they knew we regulated lake levels, but that was it. Did you feel that way?
Yes, very
I
much
thought we
so.
do desalinization down the river, and they looked at us like we had three heads. Oh, really? I didn't know that.
I suppose the underlying question would be, are they now enlightened?
Oh,
Seriously,
yeah,
I mean, do they have a
yeah.
great
I thought it was a very
appreciation
good
of what we
meeting
do?
because they each expressed a concern that we're in a position to help them with. And, and that goes a long way if we ever have a problem. Their attorney, he started and I got a little nervous. He said, yeah, we have an issue with the Ring of Fire. And I'm thinking, uh-oh. But his issue was very legitimate about people using tires and throwing couches and mattresses on the fires and it becoming toxic. And I said, boy, we can certainly put out a notice when we do renewals that that's not allowed and so forth and so on. And they were very happy with that. It was a fun couple of days, other than the drive back and the snow and the ice. But it was good meeting. Any questions? And I should have started the beginning of the meeting, and I apologize. Condolences on the loss of your mom. We didn't say that publicly, and
Thank you.
I should have started there. Contracts. Resolution to approve the Network Managed Services Agreement. Mr. Ferrara.
Mr. Chairman, my memorandum can be found on page 20 of the resolution, is on 21. The agreement is on page 22 through 30-something. Give you a little background. The district, back in 2006, installed a virtual private network. The thought at the time was fairly basic. We did not have a network in place. There wasn't really any efficiency or security, if you will, around the way that data was shared and mostly in the data sharing, but a lesser concern on the email side. So at that time, the decision was made to establish this network connection between the three main offices, Albany, Mayfield, and Watertown. In doing so, we basically established a computing environment that basically allowed us to send and receive email and access shared and private data in a very secured fashion. The work was fairly straightforward, but it entailed a primary server in Albany and a terminal server which allowed certain folks to get into that server to do certain things. There was also two subordinate servers, one in Mayfield and one in Watertown. In 2012, we upgraded that environment using a virtual server approach, which basically allowed us to eliminate the second server in Albany. The virtual server basically became the primary data secured server with a terminal server built right inside, so others could get into that server. Throughout that time, TAG Solutions has been providing us the network support on an hourly fee basis. That support in terms of dollars was starting to get on a fairly steep climb prior to this 2012 upgrade. But for the most part, we were spending somewhere around $5,300 to TAG annually, which is not a big number, albeit $5,300 to maintain the server and to basically look at things that were beyond the ability of staff in-house, myself, the compliance officer, and others. The other thing that really got me really going on the need to move this whole effort to an outside concern was the state's cybersecurity effort. As much as a virtual private network is a very secured environment, the work involved to ensure that it maintains that security, and for us, most importantly, safeguards the most important data that we need to safeguard, which is our payroll data, which includes employee names, addresses, and social security numbers. The state has made it pretty clear that outside of having the resources that some of the larger agencies and departments have, that we should be engaging a technical type firm to provide us with that cybersecurity effort. So we did use TAG to initiate an initial cybersecurity assessment of our network. We got our initial report card, if you will, a couple months back, basically saying that we have a pretty secured environment. We have some minor issues, but for the most part, the data that we need to protect is being protected and is secure. There is a secondary part of that analysis which will result in an assessment of some of the things that we can do better to further secure the environment. So that part of it is in this contract to provide that cybersecurity service to the district. So I got down to it. At the end of the day, we're spending $5,300 on average. There's some percentage of my time, compliance officer and others, that can fluctuate between 5, 6, 7, 8, 10%. So that's an additional outlay and of monies and costs based on our time. So I looked at the recommendation basically as two viable approaches. When it comes to network support, you either deploy a permanent resource or you outsource it. My estimation was an internal resource, which in many places that I've been would be the optimum recommendation, I think is too costly for us. It's at a minimum, from a salary standpoint, you're probably talking $55,000 to $65,000 a year. What this contract would cost us would be far less than that. It would be over, I believe, a 3-year period, $45,936, which is clearly far less than $65,000 plus benefits a year. And in doing that, we have a third party who is already knowledgeable of our system, in fact, deployed and installed the network, and also from a competitive procurement standpoint, in terms of the justification of using TAG. They are a New York State small business concern. We did reach out, the compliance officer reached out to MWBE firms, other qualified firms, to see if there was any interest in providing that service to us. At the end of the day, if you are not already providing that service in-house, the cost of that service will be not prohibitive, but just short of. So I didn't see any value of going out to a full request for proposal to do this job when I already had the private entity in place that's already providing the work and is doing it at a fair and reasonable price. So my recommendation is to engage Tech Solutions, not do anything in-house, allow them to continue to do exactly what they're doing, but not doing it per issue, which again would be more costly. And the resolution is
How would it be more costly if it's only $5,300 a month?
Well, because what they're doing for $5,300 is really only items that are keep the thing working. So it's not any of the, if you would go, let me just, on page, in their agreement, on page 31. If you look down, there's a service on the left. This agreement would include all of these services. Today, what they do for $5,300 is basically not even scratching the surface of these services. We only call TAG when we have an issue of critical data issues, email issues, things that we need to keep the thing up and afloat. This thing includes complete monitoring of the system every day, looking at the backups every day, making sure that the server is secured and is working the way it's supposed to properly work to satisfy all the cybersecurity issues.
There are some exclusions, though.
No, it's the only thing that's added on is
remote support, on-site support.
no. The only thing that is, if you go to the complete all the way on the right-hand side, there's only 3 items: email encryption, which we do not need.
Oh, I see.
Email archiving, which we do not need. We already do it. Web content filtering, which we do not need.
Okay.
So
I
all of
understand
those
that.
other things they will perform as part of this contract.
Okay.
There'll be no additional fees, hourly or what have you. And the other thing that it does is it takes myself and other staff completely out of the activity. The only thing that I would have to do is to make sure that the reporting, which would primarily address the cybersecurity side, is coming and it is satisfying the state's requirements for cybersecurity reporting.
Okay, need a resolution to approve the managed services agreement?
Can I?
No, go
Well, just one, in the resolution, as you can see, the last, this agreement, it is a discretionary purchase because it falls under the 50,000. Again, in terms of procuring and coming and determining that TAG is the best company to provide the service, we went through a formal justification in terms of the procurement record, looked at other companies, performed our MWBE reach out, and have determined that it is a no-brainer to use the current provider who's doing the job, and is also a New York State small business concern, so it checks that box for us.
That's an awful long motion.
Okay, I have a quick question.
Sure.
This network's been in place for 10 years?
It's been since 2006, correct?
Is it out of date? Should we look at this, the whole system?
2012,
plus services?
we did
Oh, okay.
update it in 2012. So the actual, the change, that's an excellent question. The change that, or the upgrade we did in terms of the network itself, the virtual private network itself, is that we moved all of the vendor network, the technical side of it, to Time Warner Business Class. So Time Warner, through these sonic walls, which are like devices that allow the security of the 3 locations, Mayfield, Watertown, and Albany, were previously devices that we purchased, and then we had our network company, TAG, was doing even that work to make sure that the VPN was working. Wasn't cost effective. Those sonic walls are fairly sensitive devices. They're expensive devices, over $1,000 apiece. Time Warner is a proven, in that area, technology company who performs these technical services and leases to us, as part of our contract with them, those devices. So as they age, they're replaced at no cost, and they look at all the technology and any of the issues around those devices. So TAG isn't involved in that aspect of it. So that was the other thing we did in 2012, was to segregate the VPN security side of the network to a proven company, Time Warner Business Class, is on state contract. And now, in terms of the actual network activity, email, secure data, we want TAG to do all the oversight in that area, to include the cybersecurity stuff. So we are up to that. 2012 is, fairly recent. So we have a brand new server in Albany, 2 servers in respectively Mayfield and Watertown. And I think we are several years away from having to revisit any hardware or software expenditures.
So again, we need a resolution to approve the Network Managed Services Agreement. Should we name the company?
Tag Solutions.
TAG.
I'll make that motion.
Second?
Yeah, I'll second it.
Any further comment? All in favor?
Aye.
Any opposed? Second contract, resolution to approve Granicus Webcasting Services Agreement.
My memorandum for that, Mr. Chairman, is on page 44. There's a resolution on 45, and the Granicus service agreement starts on page 46 and goes to page 53. Somewhat similar situation, another technology company, as a result of an executive order of the district and other agencies and departments of the state, agencies, have to webcast their meetings. We used a series of companies throughout the years, and the last company is a company that Granicus bought out. So that's how we came to this. And that was back in 2010 as a result of their acquisition of webcasting.com. That was the prior company. That contract expired December 16, 2015. So we are coming up to 1 year since that contract has actually expired. We've continued to allow Granicus to provide us that service because it made, again, no sense from a cost effectiveness or better service to go out, and we did look at other companies that provide webcasting services. The biggest difference in price and for the district is, number one, we do not need production services. We do not live cast our meetings, so we don't need folks to stand there with cameras, and that's thousands of dollars in many cases a month to any additional cost to actually do the technical webcast itself. So we didn't see any value there. The second part is Granicus is one of the only companies, if not the only company, that provides a platform, looks like a big computer, that enables folks like us to do our own webcasting with staff in-house. So again, we save a lot of expenses in terms of equipment and software and trying to figure out how to do it, cameras and such. So as far as the procurement record goes, again, this is a discretionary purchase. It's under $50,000. We reached out to other viable MWBE and other firms that provide this service. Again, the reason why those scenarios or options or alternatives don't make sense to us is because we don't do production. And most of those companies have no interest in or do not have the capability of providing that kind of service to us. So. So I think this self-production platform works for us. $1,072 a month would be the price extended through June 16, 2019.
Yeah, 45. It's only 2,000 a viewer. 20. Anyway.
25,000. 24,000.
A resolution to approve the Granicus Webcasting Services Agreement.
Make that motion.
Mr.
Second.
I'll second it. Mr. Hayes.
Any further discussion? All in favor?
Aye.
Any opposed? Staff and committee reports. General Counsel, Mr. Lester.
I participated in the Governor's Council meeting of Agency General Counsel, where the topics included implementation of laws passed during the recent legislative session, the general responsibilities of General Counsel, the role of the Inspector General, and compliance with ongoing obligations such as Project Sunlight. Project Sunlight, where
Sunlight, right.
if you are contacted by somebody trying to lobby the district, you need to make a little report, and we file that report. Erie, FERC, and the regulating district have all finalized their briefs for the for the DC Circuit, U.S. Court of Appeals. The joint appendix has been filed. Court has yet to schedule oral argument. We continue negotiations with DEC over the use of a fishing access point for staging and the embankment for the Hawkinsville Dam remediation. We meet with them tomorrow. And I noted that October was Domestic Violence Awareness Month. Since we didn't have a meeting, nobody wore a purple tie. So pretty much where we stand. Other than that, it pretty much was the apportionment.
Any questions or comments, Mr. Lewis? No. Compliance Officer, Ms. Pacicki.
Thank you. My report can be found on page 62. Our second quarter MWBE report was submitted to ESD. Our total was $14,421 and change. We achieved 27.2% for the quarter. Our fiscal year 16-17 master enrollment was accepted by ESD. Our second round of report cards from the governor's office and ESD will be coming out this month. They've changed a few of the things that we would be graded on. Our SDVOB second quarter report was submitted to OSG and accepted. We had a little over $3,000 in spend, so we did reach our required 6% goal for the veteran businesses. On pages 63, 64, and 65 are the contract status report sheets that you're required to review, as that satisfies the public authority requirement under 2879. And finally, I'm still working with IMC on our new permit system database. We're working out the kinks. I am anticipating that it will be up and running in time for the senior administrative assistant in Mayfield to print our renewal applications. Do you have any questions? If not, that completes.
Any questions? Comments? Thank you very much. Chief Fiscal Officer, Mr. Ferraro.
Mr. Chairman, my report can be found on pages 66 to 144. My summary district financial outlook highlights is on page 66. This is somewhat voluminous report because we did not meet in October, as you pointed out, and this contains 2 months through October 31st, closing for our fiscal month. I guess what I would highlight is that the independent audit is still delayed. I've had numerous discussions and have provided additional information. A lot of it having to do with GASB 68, which is that very recent Accounting Standard Board opinion or requirement that deals primarily with the pension liability and what the proper amount is to disclose on any agency's balance sheet. So there is a footnoting issue there. There's other issues that I believe have something to, that may have something to do with available resources at the current firm that we're using. And some of the information I have is anecdotal, but I can pretty much sense when the partner is intimately involved in the detailed aspect of the audit, then I pretty much can figure out that there's probably a resource issue there. So I think that has, and there'll be a postmortem once I receive the audit, which I expect to receive hopefully the end of this week, no later. There'll be a discussion as to some of the issues that we had in terms of the timeliness or lack of in providing that report, which we had historically received prior to the September 30th requirement by public authority to post it on our website. I've gotten one email, which is an automatic email that comes from the authority budget office that reminded me that we had not submitted our reports. I've reached out to the folks there. Not a big deal. I mean, if we're talking about the same thing next year, we could have some issues. I don't expect that. I fully expect, based on the fact that I have I've had no additional requests from the audit partner, Richard Levy-Chin, and I believe that that bodes well for a completed audit by hopefully the end of the week. Again, monthly financials are covered for 2 months. We did receive, as the General Counsel had mentioned, actually some Black River area state assessments for this current cycle. I believe that's a function of providing them with the apportionment, the new apportionment, which included the assessment statements. A lot of the beneficiaries over the years would treat that as an invoice. So we received a couple payments. The way we would deal with that is whatever the final determined assessment is for those firms. If it's the same amount, their letter, which would typically be an invoice saying, pay us your amount, would basically say, we've received your amount, thank you. If it's an additional amount or a less amount, we'll deal with it through a credit or an additional request for the balance due. Access permit database migration. We've been talking about this for several months. As refresh the board's memory, we've decided to use MySQL Server. We have a small MWBE firm doing the data conversion. We, at this point, I feel confident that we're probably 95%, 97% of the way through. The next critical step will be the generation of the permit renewals using this new system. We're going to still print them on the same forms we've always printed them on. It's just that the data file created to print those renewals will be off of MySQL Server. The compliance officer, myself, and Sue Bisco, who is the one who administers the system in Mayfield, have been intimately involved in this. The gal at IMC Consulting has been unbelievable in responsiveness in terms of every little issue that we have, and a lot of it has more to do with the expertise that Sue has in terms of how to look at navigation and is there a better way to get this? Can the report look like this? So that's probably been more, that's contributed to the delay than anything else. The database is excellent. It's got a great look. It's got excellent security, and it's going to address that whole issue that we've always had about people having to be concerned about what somebody might be doing to the data as they're looking at it. Maybe they change it. So we've addressed that. That's my report. If you have any questions.
Anybody have any questions? No. Quite thorough. Chief Engineer.
Thank you, Mr. Chairman. My report begins on page 145. It does also include the summary which I prepared for the meeting which will be held in October. In general, September was quite dry, well below average precip and inflows. Of note, we hit a second lowest average inflow for the month of September to Great Sacandaga Lake for the 85-year period of record. 17% of historic average inflow in September. And October, things have kind of picked up a little bit, especially toward the end of the month. And reservoirs now actually, with the rain that we've received, in some cases, precipitation is at or well above, certainly for the inclusive of all of the month of October, or above average. And so reservoirs have come back up to their targets or historic averages. We've made up quite a bit, if not all, of the deficit that we ran for most of the summer. Actually, since we refilled, we've basically been in deficit relative to historic averages or target elevations, and so that's been relieved to some extent with that rain that we received. That is it in a nutshell. If you have any questions, I'd be happy to take.
Yeah, I'm starting to call it the Sacandaga Pond. I'm sorry, any questions, comments?
No.
Black River, Hudson River Administrator, Mr. Hodgson.
Thank you, Mr. Chairman. My report starts on page 209. In the Hudson River area, we're gearing up for the mailing of the permits for next year. We started our yearly erosion repair around the Great Sacandaga Lake, doing riprap. And remediation work for Oakey, Gizzy, and Edwards in Mayfield has not started yet. I'm not sure what the holdup is. I'll be inquiring about that this week to see where the holdup is, but it has not started. And the Black River area, all the sheeting on the roof and the walls have been installed on the new garage, and we're looking to get the tin on there hopefully within the next couple weeks. And then our next step will be doing the windows and the overhead doors, getting it sealed up for the winter. I'll be glad to answer any questions anybody may have.
Any questions, comments? Thank you very much, sir.
Thank you.
Board member questions and comments? Anything we haven't covered?
I have something I'd like to bring up, different hat. On the Fulton Chain there, right next to the dam, we own some of the property, there's a boardwalk that goes along there with a retaining wall, and it is pretty rotten, and the town probably will be replacing it, but we were gonna approach the district here to see if we could get any, due to budgetary constraints, see if we, because it is on our property, the district's property, if we could get a little help replacing all of it. It won't be till next year, so. It's just something to consider.
You may know that.
Noted, yeah, I've noted it, and we'll take a look.
Okay, take a look sometime. We went over and inspected it. The break wall itself is all rotten. It's an old wooden break wall. You can pull chunks of it out by hand.
Okay, next board meeting, did we say December 14th? 13th. I didn't write that down, sorry.
Currently scheduled for Warren County, but location
Scheduled for
is-
Warren County, subject to change, to come back here.
Right, and I think that was the sense of the board at that time, was to come right back here.
Yeah,
So
yeah.
for the convenience of the Black River counties,
Right,
makes sense.
yeah. So I need a resolution for that, I'm sorry, and move it to Lowville. Is there a resolution?
I'll make that motion.
Second?
I'll second it.
Mr. Bergson.
And it will be a Tuesday a Monday night for a Tuesday meeting, right?
Yeah.
Okay. All in favor?
Aye.
Aye.
Any opposed? And again, we're coming up to Watertown in the winter. How did that work out?
I don't object.
It's not Stillwater. I was going to object. For the sake of my colleague,
You realize
I
gotta
need a
drive
motion to
past
adjourn?
here to go up there to come back down here the next day.
Yeah. Motion
I'll
to
make a
adjourn?
motion to adjourn.
Mr. Rosenthal.
Second.
Second.
All in favor? We are
Second, third,
adjourned,
fourth.
thank you.
Who's second?
Who's second?
I will.
Bergson.